Breaking: I am ready to negotiate with federal government, Kanu tells court. Hello viewers and welcome to InfoGist TV. The detained leader of the proscribed indigenous people of Biafra Ipob, Nnamdi Kanu, has expressed his readiness to enter into a negotiation with the federal government. Kanu took the position on Wednesday at the resumed proceedings on the 7-count terrorism and treasonable felony charge the federal government entered against him before the Federal High Court sitting in Abuja. His team of lawyers, led by Mr. Aloy Ejimakor, noted that Section 17 of the Federal High Court Act made provision for amicable resolution of such matters. Ejimakor notified the court of the decision of his team to explore the options after he moved 2 applications that was filed by his client, whereas one of the applications sought the committal of the Director General of the Department of State Services (DSS), Mr. Yusuf Bichi, to prison for contempt of court. The second motion challenged the jurisdiction of the court to continue with the trial. According to Kanu's lawyer, he will be left with no option but to activate Section 17 of the Federal High Court Act should the court dismiss the 2 applications he moved on behalf of his client. Section 17 of the Federal High Court rules states that in any proceedings the court may consider reconciliations and settlement, Ejimakor added. Now, on his part, federal government's lawyer, Chief Adegboyega Omolo, SAN, said he had earlier informed the defendant that he lacked the powers to embark on such negotiations, since it was not part of the fiat that was issued to him by the Attorney General of the Federation and Minister of Justice. He maintained that only the Attorney General of the Federation has the authority to negotiate or take further steps in relation to the matter, noting that the case borders on alleged terrorism. If he is interested in negotiations, he knows the right place, the Attorney General of the Federation Office, Adegboyega, SAN stated. Reacting to the development, Trial Justice Binta Nyako said the duty of the court was to hear the matter that was brought before it and not to act as a solicitor for any of the parties. He said it was left for the parties to agree on the way they want the matter to go. If you want to discuss with the Attorney General of the Federation, no problems at all, Justice Nyako added. It will be recalled that Kanu was first arrested in Lagos on October 14, 2015, upon his return to the country from the United Kingdom's UK. Justice Nyako had on April 25, 2017, granted him bail on health ground after he had spent about 18 months in detention. Upon the perfection of the bail conditions, he was on April 28, 2017, released from the Kuje prison. However, midway into the trial, the Ipob leader escaped from the country after soldiers invaded his country home at Afara Ukwa, Ibeku in Umuahia, Abia State, an operation that led to the death of some of his followers. Kanu was later rearrested in Kenya on June 19, 2021 and extraordinarily redemptioned back to the country by security agents on June 27, 2021. Following the development, the trial court on June 2021 remanded him in custody of the DSS, where he remained till date. On April 8, 2022, the court struck out 8 out of the 15-count charge the federal government preferred against him on the premise that they lacked substance. Likewise, the Abuja Division of the Court of Appeal on October 13, 2022, ordered Kanu's immediate release from detention, even as it quashed the charge against him. Dissatisfied with the decision, the federal government took the matter before the Supreme Court, even as it persuaded the appellate court to suspend the executions of the judgment pending the determination of its appeal. Now, while deciding the appeal, the Supreme Court on December 15, 2023, vacated the judgment of the appellate court and gave federal government the nod to try the Ipob leader on the subsisting 7-count charge. Now, this new development has caused reactions, and people have took to their social media handles to express their agitations and tell their minds. We are going to read both of you. Chukwueze Adindu wrote that the Federal High Court directs federal government and Nnamdi to pursue reconciliation. Today, invoking its power under Section 17 of the Federal High Court, Justice Binta Murtala Nyako directed the Attorney General of the Federation and Mazi Nnamdi to explore the prospects of reconciliation or political solutions in the ongoing trial of Nnamdi. Section 17 of the Federal High Court Act provides that in any proceeding in the court may promote reconciliation among the parties thereto and encourage and facilitate the amicable settlement thereof. Responding, the private prosecutor representing the federal government, Ademoyinka Omolo, SAN, told the court that he has no objections to political settlement or solution of the case, but Kanu's lawyer should discuss it directly with the Attorney General. In the same vein, Kanu's lead counsel, Aloy Ejimako, expressed no objection to political settlement. Now, Edward Chigozie also commented, federal government and Nigerian court are one. Federal government must have smuggled the idea to the Chief Judge to know what will be Nnamdi response, though he has never refused the idea of going into negotiation with the Nigerian government. Momodu Mario Andrew also commented, if I were Nnamdi I will not go into negotiation. It is Biafra or nothing. The marriage of the different regions is not working. Separate is a solution. He should have stuck to his guns like the great Odimegu Ojukwu, the Ikemba. It is Biafra or nothing. Posterity will remember you for speaking the truth and fighting what is right. Christopher Egboji also commented that the federal government should release Kanu and use him to bring peace and stop killings in the southeast. A roundtable discussion will help. Christopher Egboji also commented that the federal